Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to inform the public, so please subscribe to our channel. A common question is asked about whether or not your ex can leave the kids overnight with the new significant other. Here's the scenario. Two people get divorced. There's a couple kids. Sometimes kids are with mom, sometimes kids are with dad. Both mom and dad move on to other relationships. And I don't know, mom works out of town a lot. So the question is, on her week, during her time, if she has to go out of town for work, can she leave the kids with her significant other? Or more importantly, does the dad have right to complain about that? Is he within his rights to say, I don't like this? Or can the mom say, I don't appreciate when he goes out of town that the girlfriend is watching my kids? Is there a legitimate basis for complaining about that? Well, you got to remember a couple things. First of all, some relationships, because of the nature of it, are governed by the letter of the law of your judgment of divorce or custody order. They may well speak to whether or not this is a permitted parenting time arrangement. If so, obviously, look at the agreement. Look at the court's order, see if the court's order speaks to it. If it doesn't, then you got to figure out, well, is there a first right of refusal? Meaning that if you're not available to stay with your kids, does the other person have the right to come pick them up? But let's assume we don't have that. We just have this arrangement, and now somebody's complaining they're not comfortable with it. Well, you have to show to the court some compelling reason why your children somehow aren't safe with the other person. It may be that if the other side files a motion objecting to the girlfriend staying with the kids, that it could be that that will result in a motion for first refusal, saying that if you're not available to take care of the kids, I want the opportunity to say no, they come home with me. But that's a subject for a different time. The point is like this. In everyday life, it is the case that sometimes the custodial parent, because of work, may not be available. And then there's somebody else pinch hitting. The truth of the matter is the court recognizes that in this day and age where both parents work at sometimes active, demanding jobs, there may be other people, either in the family or friends of family, who are watching your kids. If your kids can stay at a sleepover at their friend's house where some other parents are watching them, you're going to have a hard time explaining, if you permit that, why you won't let the girlfriend, who has a direct relationship with the father, why you won't let her watch. In other words, you're going to have to explain how this is not in the best interest of the children. And you may be able to succeed in doing that because of the habits of the person and whatnot. That having been said, be prepared. If you're going to raise that issue, the other side's likely going to raise an issue in kind. So if you are letting, for example, your kids stay with your significant other when you're out of town, don't expect that if you complain on the other side that they won't say, well, I don't want it then either. And then all of a sudden both are inconvenienced. So to be very careful, my recommendation is that if the relationship supports it, that you have a sit down, you talk, air the problem out in public, get it out on the table, say, look, I don't like this. What don't you like about it? Why? You don't like my girlfriend? It's not that. You've had 3 girlfriends in the last 4 weeks. In other words, whatever the complaint is, get it out there in the open. Maybe the complaint will be well taken. Maybe they'll understand it. Maybe there's a way we can tweak it. Maybe you'll agree to a first refusal kind of thing, without the court getting involved. If you can't, though, obviously motion is going to have to be filed. Now, if you have questions about your case, reach out, and of course, we'll be glad to help you out.